Okay, everyone, we're in the home stretch. We're talking about a rule that a lot of people get wrong, a lot of people don't understand, and it's Rule 804, exceptions to hearsay when the declarant is unavailable. I just have to get this out at the beginning. Please, no one in this program ever say that because a declarant is unavailable, their statements are admissible as an exception to hearsay. That is not the case. There's two large groups of exceptions. One group, 803, which we've just talked about, and all those various exceptions, apply to declarants who are available. And these exceptions apply to declarants who are unavailable. 804A gives a set of criteria for unavailability, and we'll take a read of it right now. A declarant is considered to be an unavailable witness if the declarant is exempted from testifying about the subject matter of the declarant's statement because the court rules that a privilege applies, attorney-client privilege, things like that, refuses to testify about the subject matter despite a court order to do so, like flees the country, testifies to not remembering the subject matter, cannot be present to testify at the trial or hearing because of death or a then existing infirmity, physical illness or mental illness, so death or coma, essentially, is absent from trial or hearing, and the statement's proponent has not been able, by process or other reasonable means, to procure the declarant's attendance or their testimony under the various exceptions. And in mock trial, unavailability can't be claimed if a witness was chosen not to be called, but they're an available witness under AMPTA's statements, just so you know. Essentially, almost always, this is death. Like if between the time of the incidents occurring and the time of the trial, someone died or became very ill, or was just unable to like make a long traversion across like continents or countries to like be there to testify. Those are the criteria for being unavailable as a witness. Just because you are any of those things does not make your statements admissible. If that were the case, then testifying to not remembering would make all of your statements otherwise admissible, things like that. So this is a criteria, a set of exceptions that applies to people who meet this criteria under 804A. I could break down a couple of these various exceptions. Some are more likely to be used than others, but it's late, there's lots of videos, and at the end of the day, a lot of these exceptions get to the same type of thing. Again, with hearsay, we're concerned with the trustworthiness and credibility of the statements we're eliciting. And it's very difficult to authenticate statements made by unavailable witnesses because they can't be there to give context to what they said or any reason to trust them more than other statements. But it does give rise to a specific group of issues. So if you have former testimony, it's said to be okay in the case of unavailable witnesses, because while we can't corroborate independently if anything's changed or any of that stuff, it is a pretty high indication of reliability, as we've talked about earlier, because you gave the statements under oath. Statement under the belief of imminent death, essentially last words. Your last words are admissible. You tend not to lie with the last words you get to speak. A statement against interest. This is a pretty big one, but statements that self-incriminate someone or expose them to liability for a crime are admissible as exceptions to hearsay as statements against interest. To give an example, last year, Whit Bowman and Cameron Poole committed this robbery together. Cameron Poole tells Whit how it went in the immediate aftermath of the robbery and admits to committing the crime. Now, essentially, confessions in that manner are statements against their own interests, statements that if they were to be found out would expose the person to criminal liability. If made in confidence, as the statement between Cameron Poole and Whit Bowman was, there's no reason for him to lie in that instance. Does that make sense? Like, why would you lie to expose yourself to criminal liability? That's how the law sees it. Statement of personal or family history, pretty explanatory, or a statement against an opposing party's interest when the opposing party is someone who caused the declarant's unavailability. So, like, I guess usually it would be like wrapped up in last words, but if I sent you into a coma, I come out of the coma and make a hearsay statement or like repeat a hearsay statement, and that statement is against the person who put me in a coma, then that's okay. Those are just some of the exceptions to unavailable witness testimony. Sydney Park is an unavailable witness. While you can get her statements in as party opponent on defense, you can maybe point to some of these statements. I'm thinking especially statements against interest, but I guess it doesn't expose you to criminal liability. But there's definitely some arguments to be made here about Sydney's statements on plaintiff if you want any of them in. You can look at these exceptions as well as the ones in 803. That's that rule.